On August 23, 2021, the federal government initiated a nationwide push for employer COVID-19 vaccine mandates by publicly declaring that the available vaccines held full FDA approval. President Biden, speaking from the White House that same day, stated that the FDA had granted its full and final approval. This split-screen comparison reveals a contradictory regulatory reality. On the left is the public statement. On the right is the FDA's own documentation issued that same afternoon, acknowledging that the approved product was unavailable and the product actually being administered was legally distinct. A fully licensed medical product operates under a Biologics License Application, or BLA. This designation confirms the completion of the FDA's rigorous clinical trial and review process. By contrast, the vaccines actually available in the United States were authorized under an Emergency Use Authorization, or EUA. Governed by Section 360BBB3 of Title 21, an EUA designates an investigational product which, by federal law, carries an express statutory right of refusal. We are going to examine the administrative architecture that allowed for this regulatory conflation and how federal employees are now attempting to use the Federal Tort Claims Act to pierce sovereign immunity. By substituting an investigational EUA product into a mandate legally designed for a licensed BLA product, the government effectively removed the mandatory statutory right to medical refusal. Federal agencies moved rapidly to enforce compliance. On September 13, 2021, the Federal Reserve Board implemented its own employee vaccine mandate as a direct response to executive guidance. Stephen Bennett, a senior management analyst at the board, submitted a formal exemption request. He accurately identified the EUA/BLA legal distinction and provided research showing diminished mRNA vaccine efficacy for individuals undergoing active cancer treatment. The board did not engage with the merits of his request. Instead, it dismissed his regulatory analysis and denied his exemption by substituting the government's conflated public guidance. This institutional posture was not limited to the Federal Reserve. According to sworn congressional testimony from former CIA officer James Erdman, parallel enforcement was occurring within the intelligence community. The CIA assigned non-compliant personnel for investigation by its counter-espionage department. Employees asserting their statutory right of refusal were investigated under the suspicion that they might be foreign spies. When targeted by these policies, employees at agencies like the Federal Reserve have few avenues for recourse. They are exempt from the Civil Service Reform Act, leaving them without Standard Merit Systems Protection Board appeal rights. The institutional enforcement of the mandate relied on absolute conformity to conflated guidance, penalizing the precise analytical accuracy these employees were hired to provide. The laws protecting individuals from mandatory experimental treatments are legislative substitutes for judicial accountability, created in response to specific government failures. The foundational failure occurred between 1932 and 1972, during the Tuskegee syphilis study, where the government withheld treatment from subjects without their knowledge. A $10 million settlement in 1974 preempted a court ruling on the Tuskegee claims. This forced Congress to step in, passing the National Research Act and creating the informed consent regulations known as the Common Rule. A second major failure occurred during the Gulf War, when the Department of Defense administered investigational anthrax vaccines to military personnel without consent. The resulting congressional backlash led to Section 980 of Title 10, prohibiting the administration of investigational drugs to service members without consent, the direct statutory model for the civilian EUA framework. This timeline traces the legal lineage. Tuskegee led to Title 45, Part 46, establishing the baseline for human subject protection. Following a separate path, the Gulf War anthrax mandate generated Section 980, birthing the civilian statutory right to refuse an EUA product. These statutory rights are not optional guidelines. They are legislative mechanisms engineered to prevent federal agencies from bypassing medical consent. For a citizen seeking damages for the negligence of a federal employee, the exclusive legal mechanism is the Federal Tort Claims Act, or FTCA. Procedurally, an FTCA lawsuit must name the United States of America as the sole defendant, rather than individual agencies or officials. In this case, the Department of Health and Human Services served as the origin point for the guidance that conflated EUA and BLA products. When facing an FTCA lawsuit, the government's primary defensive maneuver is invoking the discretionary function exception. This exception protects federal agencies from liability when their actions involve policy-level judgments or the balancing of public interests. HHS officially invoked this exception to dismiss Stephen Bennett's administrative tort claim. The agency charged with enforcing informed consent regulations is using a discretionary shield to avoid liability for misrepresenting those exact rules. To seek true accountability, plaintiffs must actively bypass the government's immunity shield using firmly established Supreme Court precedents. The first tool to pierce the exception is the 1988 Supreme Court decision in Berkovitz v. United States. The Berkovitz ruling established that the discretionary function exception offers no protection when an agency violates a mandatory, unambiguous federal statute. Applying Berkovitz here suggests that HHS possessed no legal discretion to misrepresent the statutory text defining an EUA product. The second tool is the Supreme Court's 2024 ruling in Loper-Bright Enterprises v. Raimondo. Loper-Bright eliminated Chevron deference, removing the requirement that courts defer to an agency's interpretation of a law. Under this new standard, courts, and not administrative agencies, hold the exclusive authority to determine what a statute means. This prevents HHS from claiming its conflation of BLA and EUA statuses was a reasonable interpretive choice entitled to judicial deference. By combining Berkovitz and Loper-Bright, plaintiffs create a legal environment where sovereign immunity cannot protect an agency that disseminates factually inaccurate statutory information. The enforcement of the mandate was paired with external information control. Federal agencies coordinated with third-party organizations like the Virality Project to manage the public narrative regarding regulatory information. These organizations tracked directives using JIRA, a project management software that assigns system-generated sequential ticket numbers. A technical audit reveals a glaring anomaly. This grid visualizes the exact 1,019 sequential tickets covered by the subpoena, ranging from VP 74 to VP 1093. Of those, 868 are entirely unaccounted for. Only 15% of the sequence was actually produced to Congress. In sequential software architecture, an 85% data gap is highly anomalous. It indicates that the vast majority of the enforcement record has not been disclosed. This statistical gap prevents a full audit of how agencies coordinated information suppression. Until the full sequence is produced, the extent of the government's coordinated effort to hide these regulatory distinctions remains inference rather than documented fact. By April 2025, the initial mandate infrastructure within the military had begun to collapse. Secretary of Defense Pete Hegseth issued a formal directive to reverse disciplinary actions taken under the prior administration's policy. The Department of Defense explicitly classified the previous mandate as an unlawful order, enforcing an experimental vaccine. A massive administrative unwinding is now underway, resulting in discharge upgrades and the opening of class action litigation for military back pay. The policies now being unwound as unlawful are the exact same mandates enforced with zero administrative tolerance just 3 years ago. The outcome of this case will define the future of informed consent. If these statutes can be bypassed through semantic conflation, the legal protections established in the wake of historical failures risk becoming optional guidelines rather than mandatory constraints.